Okay, so welcome everybody. My name is Mike Fiffick. I am the managing partner here at Fiffick Law Group, a legal shield provider firm here in the Commonwealth of Pennsylvania. I have offices in Pittsburgh and now in suburban Philadelphia. I'm very happy to say. We just picked up a great attorney, Kevin Frankel, who's working with our members on a lot of this advanced estate planning and trust planning things. So very happy to have Kevin on board. Joining me tonight from my staff should be somewhere in here in this panel of folks, right? I have Noemi Reyes. She is
hi everyone.
Say hi. I have Belinda Lason, who is our supervisor.
Hi everyone.
And then my very own daughter, Claire Fiffick, who is my marketing director. She's floating around in somewhere too. So, I am inviting all of them to chime in as I go through our slide deck tonight to add some nuggets to the things that I say, or to correct anything that I say wrong, which is highly likely. So anyway, we're going to go through a little potpourri. It's a bit of a misnomer, family legal plan potpourri. I actually am going to cover more than just the family plan. So here are the things that we're going to talk about this evening. We're talking about the 25% discount myths and some trial defense key points. These are things that frequently come up that we have to talk to members about from a benefit perspective. So we thought that it would be good to maybe refresh or reaffirm some things that you understand about those types of benefits. We will talk about business plan conflicts of interest and coverage myths. We talked a little bit about this if you caught the provider power hour, which wasn't recorded. So if you missed it, we're going to cover a little bit of that stuff again this evening. Associates getting involved in the intake process, do's and don'ts. This is something that happens for us periodically, and we just want to talk a little bit about the right way and the wrong way and the things that we can and can't do when associates want to help their members. And we appreciate that they want to do that. And then we'll talk a little bit about the LegalShield app and a little bit of our online will tool for anybody that works in Pennsylvania. So here's the first part. We're going to talk about the 25% discount. Not fact or fiction. The discount applies to all fees charged by your provider lawyer and referral attorneys. The answer is it's fiction. It applies to matters handled on an hourly basis only. So other fee arrangements that exist out there for customers that may be hiring an attorney include flat fee engagements, contingent fee engagements. Law firms typically will charge through to their clients a variety of other fees, including they will charge for paralegal time, and sometimes lawyers will offer payment plans for engagements. So let's talk a little bit about the flat fee, sometimes called the fixed rate. This fee arrangement is a set amount that the attorney charges, regardless of the length of the case or how often you're in contact with them. And so this is something that is growing in popularity. According to a recent survey, about 84% of law firms offer what are referred to as alternative fee arrangements to charge clients for their services. So alternate to the hourly, right? The hourly is kind of the paradigm or the standard that everybody thinks about, that it's going to be time and materials sort of thing if you're a contractor. Over 70% of law firms perform work under alternate fee arrangements will use flat fee billing when servicing clients. So this is something that's definitely growing, and firms that do this for an economic reason, because they can usually try to work within the fee that they're charging in an efficient way in order to be profitable. So some examples of flat fee engagements, at least for us, would be a DUI, driving under the influence, or driving while intoxicated, whatever it's called in your particular jurisdiction. Non-felony criminal matters. So maybe somebody is charged with assault and battery because they got into a fight in the neighborhood. Relatively minor criminal matters. Attorneys will oftentimes charge on a flat fee basis. They usually resolve somewhere early in the process. Deed preparation, very common request that we get. We probably get multiple of these, if not every day, certainly every week. Formations for business entities like a limited liability company of some kind. Those are usually handled on a flat fee basis. Trademark applications or perhaps copyright applications are often handled on a flat fee basis as well. Will or trust preparation that isn't covered by the family plan, if the family plan is applicable, law firms will often charge on a flat fee basis for those types of things. Sometimes, if there's like a small claims court or an arbitration proceeding that is going to be relatively limited in scope, firms will charge on a flat fee basis for those, and maybe like a small claims court appearance. There are many, many other situations that could result in a flat fee engagement. So the mileage may vary on those, but those are some examples of how they would be charged through. And before I move on to trial defense benefits, so the next question that you might ask is, well, are members going to get any type of a discount on flat fees? And I would say that really depends on the provider firm and it depends on the referral, right? I would say that the vast majority of members have an understanding that the 25% basically applies to any fees that a lawyer is going to charge to LegalShield members. That's a very, very common misunderstanding because that's kind of the easy way to say that this is how it works, rather than to say, well, it's only an hourly and it's not on flat fee contingent. That gets a little bit more complicated. So we will typically give some type of a courtesy discount on these other type of fee arrangements, these alternate fee arrangements. And I think that most referral lawyers probably will as well. But I can't say that in all instances there will be a discount. And if there is, I can't say exactly what it is. But that's the technical coverage answer for the 25% discount. Noemi or Belinda, do you have any comments on that at all?
Mike,
No.
sorry.
Sorry.
We talked at the same time.
Yeah, and feel free, if anybody has any questions about this, just chime in. I'll be happy to answer them as we go along.
Go ahead, Noemi.
I was just going to say another example of instance where we would charge a flat fee would be any type of bankruptcy, whether that would be a Chapter 7 or a Chapter 13 versus personal or business, that would be a flat fee.
Okay, Jimmy, you have your hand raised. What question can I answer for you?
Yes, I know that with the launch by LegalShield, the member receives one LLC, as part of launch. If the member wants a second LLC, would that be at a flat fee or would that be at a 25% off the hourly rate? I would be very surprised if it wasn't handled on a flat fee basis, right? It probably depends on what they want, but if it's a single member LLC, typically it's going to be handled on a flat fee basis. When you get into multiple members in an LLC, it can be a little bit more complicated, but your garden of variety, 95% of the time, type of an LLC formation will be on a flat fee basis, I'm sure. Okay. All right, so let's talk a little bit about trial defense benefits. So, trial defense benefits under the family plan is available for civil actions filed in the trial level, state, or federal court. So the takeaway from that is that it doesn't handle all types of litigation, right? And there's all different types of litigation. I use that term generally, where there are two parties to a dispute that is decided by some type of fact finder or arbitrator or whatever it is, where there's a decision going to be made by somebody other than the parties. So that's what I generally call litigation. The trial defense benefits only covers civil actions, civil, not criminal, civil, filed at the trial level, state, or federal court. So this is another thing that we have a misunderstanding about relatively frequently whenever we're talking to somebody about it.
Also, Mike, the member
Yeah.
must be named as a defendant.
Yeah, and the member has to be named as a defendant. Yeah, they have to literally be, their name has to be in the caption.
So examples of legal proceedings that are not covered by this benefit. Any type of claim that is an administrative claim. So claims that are adjudicated before an administrative body of one kind or another, whether that's at the state level or at the local level. Local governmental entities will have adjudicative proceedings. So one example is unemployment compensation benefits. If there is an unemployment compensation proceeding and the member is a party, is part of that litigation, and sometimes a member can be drawn in because this especially happened after COVID, where everybody was getting the extra unemployment compensation benefits because the government paid them out willy-nilly. After COVID was over, the government took stock of who they paid and realized that they probably paid people who were not eligible for those benefits. And they filed what I would refer to as a clawback type of a proceeding, where these people were now in the position of being a defendant, where the state was saying, we overpaid you, you have to give us the money back. Those were not covered by the trial defense benefits. Insurance coverage disputes. There is a coverage between the insured and their insurance carrier for perhaps auto insurance benefits or health insurance, disability benefits. Sometimes there's an internal dispute resolution process if a medical procedure is not covered, or if a disability insurance claim is denied, and there's some type of appeal process that's happening that's within the contract, those are not going to be covered by trial defense. Arbitration proceedings before the American Arbitration Association or another type of an alternate dispute resolution organization, those are not civil actions filed in the state or federal court. And arbitration clauses are, we're seeing those more frequently in contracts, especially consumer contracts with big companies. They are trying to avoid class actions by forcing their customers into arbitration proceedings whenever there's a dispute of some kind. You might see arbitration proceedings in contracts for nursing homes or other types of care organizations. Those are common examples. But they're going to force you into an arbitration proceeding, and those are not in the state trial, state court or federal court. Those are alternative dispute proceedings. Matters that involve professional or occupational licensure, right? Those are not going to be covered. So maybe you have somebody that's got a license as a beautician or an esthetician or something like that, and they receive some type of a citation from their state regulatory entity that they've done some bad thing. Those aren't going to be covered either. Those are probably arising out of a business anyway, but they are also not civil cases. Juvenile court matters aren't going to be covered. So if a child is being involved in an adjudication of delinquency of some kind, it's not going to be included. Involuntary commitments, if you've been placed in a facility against your will because you're not well mentally, those aren't going to be covered. Post-judgment collection or enforcement actions. So anything that happens after any type of a judgment in a court is not going to be covered. That means appeals, that means collection action, where somebody had a judgment entered against them, perhaps a year ago, 2 years ago, 6 months ago, whatever it is, and now they've received the notice that their wages are going to be garnished, or that their house is being put up for sheriff's sale, or something like that, where the creditor already has secured a court judgment against them. And now they're trying to collect on it. There are continuing legal proceedings. Those aren't going to be covered by the trial defense benefit. So, Noemi or Belinda, anything else to add to that?
Yes, a very big one. A very big one is business related matters.
Yep.
Even if you have the home business supplement, you cannot get trial defense benefits. If you're a landlord and you're being sued by a tenant, even if you have the home business supplement, those trial defense benefits will not apply. There are some small business plans that give a little bit of trial defense benefits, to them, but business matters, absolutely not. Those are excluded. Also counterclaims. So if you're being sued, the defense part might be covered, but if you want to assert a counterclaim, that's going to be under the preferred member discount referral.
Yeah, we have a couple questions here. So Teresa, why don't you go first? And
So
then Jimmy.
what type of civil actions does it cover then?
So it's going to cover a garden variety lawsuit, like maybe your neighbor filed something in a petition action, you have a dispute with a co-property owner. We had a call on the street today where two people who own a property together couldn't agree to sell it. Maybe there's some type of a partition action that is filed.
Property line disputes. Collection
Um,
actions where you have proof that the debt was paid. Landlord tenant issues where the landlord's suing for rent when it's been paid, or there's other defenses available to the tenant.
Disputes with contractors.
Those are, when there's a good valid defense, contractor suits. Yep. We just approved one recently where there was a contractor involved. Absolutely.
Yeah, those are some common examples of what we see that people get themselves involved.
Thank you.
Sure. Jimmy, did you have a question?
Yes, this goes along with what Belinda mentioned, and I was trying to pull up the contract, but anyway, let's say if somebody is a landlord and has the home business supplement, because Belinda said that if the tenant files suit or something like that, it's not covered. I don't know why, but I thought for some reason that with the home business supplement, the trial defense is covered at a 25% discount. Am I
I think
correct?
you're right. I think it would be.
Well, it's a discount. You get the discounted referral, but when I review for trial defense, that's for the free attorney hours. A 25% discount is not free attorney hours. You're paying the attorney's hourly rate at a discount. Trial defense benefits are benefits where you have accumulated trial defense hours, both pretrial and trial, that in the old plans are accumulated. There's a flat scale for the current new family plan, where you have so many hours that you will get at no charge of the attorney's hourly rate at no charge. And then after that, it's at the discounted rate. Whereas if you have the home-based supplement and you're sued, it's just like a regular preferred member discount referral.
Yeah, but I'm glad you brought that up, Jimmy, because whether it's under the family plan or not, if there's no trial defense benefit, we will always offer somebody coverage under the preferred members, right? So, Rick, did you have a question?
Yeah, real quick. So we're talking about the trial defense portion of the membership.
Yep.
Like the 60 hours up to 300 hours after 5 years?
Yes, that's exactly.
We're not
right.
talking about the trial defense supplement.
No. This is under the family plan.
Okay.
Under the family plan.
Okay.
Okay, so some other things to be thinking about regarding the trial defense benefits. Pre-existing matters are not eligible for the free hours, right? Pre-existing can be eligible for the preferred member discount, but pre-existing would not be eligible for the trial defense benefit. So what exactly is pre-existing? Because this is something that sometimes we get a little confusion about. Pre-existing means it's the dispute that arose prior to the date of the membership, right? The facts and circumstances of the situation arose prior to the date of the membership. Pre-existing, the triggering event is not the date that the lawsuit is filed. Right? So if you get the membership 2 days before the lawsuit's filed, that doesn't mean that it's covered. The dispute typically arises before the lawsuit's filed. It always does. So that's what we look at. What are the facts about the situation? Was this something that was already brewing before the membership was purchased that would make it pre-existing? That's not necessarily a bright line type of a standard for you, because sometimes it can be a little difficult to determine when that dispute arose, but usually it's pretty clear from a practical standpoint. If you read the lawsuit, it typically gives the history of the relationship between the parties and when the dispute arose. We kind of have a pretty good idea of when that dispute came to fruition. You could have a contract that's signed between two parties that's going along just fine, right? The beginning of the contractual relationship doesn't define when the pre-existing period happened. It's really when the dispute arose. That's how we would do it. So you could be under a contract with somebody for a couple of years, everything's hunky-dory, and then all of a sudden some maybe payment dispute arises that ultimately ripens into a lawsuit. It's when that payment dispute arose is really sort of when the clock starts ticking. That's the beginning of what pre-existing is. Belinda has already mentioned business-related matters. No trial defense benefits. Frankly, there's really no benefits at all under the family plan for business-related matters, not even preferred member discount. That's the technical answer to that question. I can't say that we wouldn't offer somebody preferred member discount for something that was a business-related matter. We probably would, but I can't say that for all of the provider firms. But I think that the tendency would be that if the member does want to retain, it would probably be extended the preferred member discount. But the technical answer under the family plan is that there are no business benefits under that plan at all, not even under the preferred member discount. So criminal matters not covered under trial defense. It's civil suits, matters that are covered by an insurance policy. So if you've caused an accident with a car and somebody sues you for that, and you've got insurance, that insurance is going to provide you with the defense. That's something that would technically not be eligible for trial defense benefit. Bankruptcy matters, or any type of a matter where the underlying dispute involves drug or alcohol use or some other type of involvement for the matter. And that can be a bigger issue now that marijuana is becoming legal in many states and many jurisdictions, or you have medical marijuana as well. There's the membership does not speak to that issue. So that's going to be something that we're going to have to address on a going forward basis as a company and as provider firms, that if somebody has a medical prescription for marijuana and they are using it legally, is that going to be covered by the trial defense benefit? That's really something that I think ultimately the company is going to have to answer. I'm not aware of any dialogue that has occurred about that. Noemi or Belinda, have you heard any dialogue about that at all?
Nope,
No,
not
I
as yet.
have not.
No, it's probably something that would be good for us maybe to bring up with the company and figure out how that's going to be handled. So, Jimmy, do you have another question?
Yes, this goes along with what you were saying. I think you may have just answered the question, but let's think as far as drug, if it is like a prescription drug or something like that, then would it be covered or not?
Yeah, I think no matter what, even if you have a prescription for medical marijuana, you're not allowed to drive your car under the influence, right? So it probably isn't going to provide you with access to this benefit under the plan. But again, that's really it's going to be a coverage question for the company. I'm personally not aware of any requests for coverage for this benefit in Pennsylvania that we've had to grapple with this particular issue, but I'm sure that it's coming at some point. We'll have to figure it out. But, again, using alcohol, of course, is legal too, right? Just like marijuana, but you can't drive drunk, you can't be impaired. So I think that the same rules are probably going to apply for medical. Teresa, did you have another question?
Yeah, so I'm just confused a little bit about the insurance policies with matters.
Sure.
So whether it's auto or home insurance, so are you saying that if it's an issue with the insurance company, or like surely they can get advice if they're either the insurer is not covering something that they thought should be covered, say for something with the home, or if they are in a car accident, do they get advice? Or is
Yeah,
this
well-
strictly just trial defense is not being covered?
That's a good clarification. Thanks for bringing that up. We're only talking about the trial defense. We will always consult with somebody about these matters. We'll consult with them about everything. I don't think there's anything other than business, right? In the family
Right.
plan, we wouldn't consult with them on a business related matter. There are no benefits under the plan for business, right? But for any type of an insurance dispute, we'll always consult with somebody. We'll review documents for them, and where it's appropriate, we might even write a letter on their behalf. This really covers a situation where you are a named party in a civil action that is covered, for which you have insurance coverage. So you've caused an automobile accident. You are driving golf balls and you hit somebody in the mouth with your homeowner's insurance. I think would cover that in most states. Or you're being sued for host liability and you have coverage on your policy for that. Those are the types of things where there's no trial defense benefit. We wouldn't be entering into that case and offering a defense for you if it's covered by your insurance policy. So it's really kind of a double coverage type of a thing where they're just not going to provide coverage where you already have it. So Belinda, did you want to say something about that?
Yeah, we do a lot of pre-litigation letters and consults and document reviews and even letters to the insurance companies like, hey, Mr. Smith, your insured was involved in an accident. He's trying to get you to address the claim from the other party. Let's go here, to get them to provide coverage. We do it from the other side too, so I mean, we will always consult on insurance issues.
Absolutely. Okay, let's see what else I got. So a couple other shirt pocket notes regarding the trial defense benefit. It covers attorney time only. So things that it doesn't cover would be costs. That might be filing fees, that might be overnight mail, that might be depositions. There are lots of different costs that are incurred whenever you're in litigation. The costs would not be covered. Those are all payable by the member. It wouldn't cover paralegal time. So if the law firm uses paralegals and they bill that time through to the client, which is very typical, very customary, it wouldn't cover the paralegal time. The member will probably be required to pay a retainer up front. So some members, if they have coverage under the trial defense benefit, would say, well, I want my 2.5 hours or 4.5 hours of free time first before I pay you anything. And the law firms are not going to get involved in litigation unless they have some assurance that they're going to get paid for the uncovered hours too. Because once they put their name on the lawsuit on behalf of the member, and they have to get the court permission to disengage from the litigation and stop representing the client in the case. And so that takes time for them to file a motion to withdraw from the case. And sometimes the courts say no, and then they're stuck in the case. So we're going to typically require a retainer to be paid up front to cover costs and some anticipated amount for the uncovered amount of time that could be used on the case. I will also say that this is a very common request, will you take payments? That's really up to the law firm whether they're willing to take payments. The plan doesn't really speak to that particular issue, but I would say that typically attorneys are probably not willing to take payment plans, especially on litigation, because litigation can be very expensive and the bills are going to rack up there pretty fast, and they don't want to have a bill get ahead of them on those cases. So probably aren't going to accept a payment. Okay, let's talk about business plan conflicts and coverage issues. So now we're moving into the realm of the business plan. Really, I'm talking about the business essentials and plus plans, all of those types of plans that cover a single business entity. So let's talk about conflicts. So businesses that are covered by a business plan oftentimes have multiple unrelated owners. Not always, but that's not necessarily uncommon. They're going to have 2 or more owners that aren't necessarily spouses or family members, but even if they are, it doesn't really this still applies. Sometimes soft or hard conflicts arise between either the owners and the business or between the owners themselves. It's not that uncommon. So let's talk a little bit about hard conflicts and soft conflicts. These are my terms. These are just my terms. So a hard conflict. Here's an example. A dispute arises between two business owners, right? So maybe one business owner is accused of misappropriating money that's payable to the business. Common example that I'm working on right now, you've got two members of a limited liability company. One member collects the rent payments from the tenant and doesn't turn the rent payments over to the business, right? That's misappropriating money that is payable to the business. And for whatever reason, maybe they feel that they're entitled to it, whatever it is, there's still a dispute there. Maybe it's money that's a dispute over the direction of it, where an owner won't sign something or agree to something that is holding up a business process along the way. Sometimes lockouts happen where one business owner locks the other business owner literally out of the business by they change the locks, or they've changed all the passcodes on the software and the computers or whatever. There's some type of hard conflict that happens between business owners. We're not going to be able to help one business owner with a conflict against the other business. That's not what the plan is there to cover. It's really, the benefits are to inure to the business. So those are conflicts of interest. Soft conflicts are ones that are conflicts, but they might not necessarily seem like they're conflicts at first glance, but they really do give rise to the conflict of interest. So perhaps owners call us. This is a very innocuous request, right? Call us and they want us to prepare an operating agreement for the business.
So soft.
Seems like a very, very normal type of a thing. That gives rise to the potential for a conflict of interest, because that operating agreement is going to contain terms that that pertains to one owner's rights concerning the company, or one owner's rights vis-a-vis another owner. And they're going to have their own individual interests involved in having those provisions drafted. So whenever we do take those engagements, but we ask all of the business owners to sign, acknowledge that there's a conflict of interest there, to waive the conflict of interest, and to agree that in the event that the parties reach an impasse or don't agree about something, what happens, in that situation? What happens in that situation? But that is a potential, what I would call a soft conflict. Sometimes they don't really ever have a disagreement. They just want it to be put together and everything's hunky-dory, and they can agree to all of the terms of the operating agreement, but it isn't always that way. Especially if you're representing maybe a minority owner who wants to protect their interests so that they don't get pushed around or have their minority interest impaired in some way, or you're representing a majority owner who wants to maintain control of the business and have the ability to impose their will on minority businesses. You can see pretty easily how a conflict of interest could really arise there. So another example is an owner wants advice about a personal guarantee for a business loan, right? If you've ever borrowed money, where your business is the borrower, you're going to almost always be asked to sign a personal guarantee for a business loan. And it's not unusual for a business owner to seek advice about, should I sign this guarantee? What does this really mean? Can we limit the guarantee in some way so that I'm not on the hook forever and ever on this loan in the event that the business defaults, on the loan? So again, that's a conflict of interest, because that's really something that's personal to the member, and they're adverse to the interests of the business or the interest of their business partners. They may want to protect themselves, and that desire to protect themselves may jeopardize the business's ability to get the loan or change the terms of the loan or whatever. Maybe you've got a lease or other type of an agreement between an owner and the business, right? Very common. Business owner owns the property, the business rents the property from one owner, right? That there's a conflict of interest that arises there between those two. Or perhaps the business owner wants to sign some type of a management agreement or a property development agreement, or these multiple owners buy a piece of real estate that they're going to renovate and flip, and one of the owners is a contractor and he wants to have a contract with the entity that owns the property. There's going to be a conflict of interest that arises there. So these types of things happen, and we're going to have to make some coverage determinations or calls on whether those are going to be covered by the business plan. Probably not in those situations. Some other coverage issues that we have, and this isn't conflicts, but coverage issues. Business owners who have requests that are not directly related to the business, right? The benefits of the business membership inure only to the covered business. So there are no benefits that inure to the owners personally. It doesn't inure to other businesses owned by the owners. It doesn't inure to the employees of the business, right? So a business owner might call in to say, one of my drivers got involved in an accident or got a traffic citation, was having some problem with their license, which is a problem for me, because if this guy or gal can't drive, then I've got a problem for my business. What should I do about it, right? How I need somebody to talk to my employee to figure out how to handle whatever the situation is. That's not really something that the business plan covers. And those can be a little difficult for business owners to understand and deal with, because most business owners just want it taken care of. They're sort of goal-oriented or results-oriented, and it's a little bit difficult sometimes to get involved in those types of coverage determination. Other examples, an owner calls in with a personal legal issue entirely unrelated to the business. My kid got arrested last week. What do I do about it? I will have to say that from a practical standpoint, we'll probably talk to the member about that, but remind them if they don't have a family plan or a personal plan, that they probably are going to want to get a family plan. We'll always direct them back to a sales associate if that's how they purchase the membership, or they can call customer service and get that as well. Owners, another example is an owner who calls in with a question for a different business that they own. Not unusual for business owners, they're entrepreneurial, they've got a variety of businesses, and they would like to call in on all of those businesses. Again, these business plans cover one business, unless they have the home business plan, but that's not the plan we're talking. Maybe owners wants advice about a personal liability for business debts. Again, that's not really something that the business plan is intended to cover. It's supposed to be advising just on the business, not on the owner's individual liability for business debts. Belinda or Noemi, do you have any comments about any of that at all?
No, I mean, we do encourage them to get family plans.
Yeah.
And try and connect them with LegalShield, because you would be surprised how many business owners we have who call in, I want to get a divorce, or, my neighbor is causing issues. It's completely a personal related matter. And, in those situations, obviously, if it's an urgent situation, Noemi usually brings it to my attention. Like you mentioned, the son getting arrested, that sort of thing. We certainly don't like to leave people hanging. And sometimes we'll try to get them connected with an attorney as a courtesy, so it would be a full fee type referral if it's urgent. But if there's time to get them a family membership, to get their, to get that addressed, we certainly try to connect them with LegalShield, and explain the difference between and the business plans.
Right. Rick, do you have a question?
I do. First of all, let me just say this is great. I really appreciate you doing this, because, I'm sure you guys run into conflicts where the member was told something by the associate, but it really doesn't fit with the coverage. So this is really good to get kind of some of this flushed out.
And you all could do the very best that you possibly can about explaining the benefits. And because of human nature, they only retain a certain percentage of it, right?
Right.
So
Right.
they may think that they heard something, but they didn't, right? But it is what
Right.
it is. However they came about
Yeah.
to understand this, our job is to
Yeah.
help them understand it correctly.
Yeah. Yeah. And it probably works both ways, but it's good that you talked about the coverage for the one business. So is that determined by the tax ID number that they enrolled in for that business plan?
I don't think we see the tax ID number. So Belinda or Nomi can correct me if I'm wrong, but we never see it.
No, we don't see the tax ID. We typically just go by the name of the business.
Okay.
Yes.
That's how it identifies it on our end when we look at it.
Okay. So then what is the difference with the home business supplement? Because I know now that it can cover multiple rental units, but did you say that they could have multiple businesses under
Yes.
the home business?
Yes. The home business product is something where the owners can only be spouses, right, or domestic partners, whatever the terminology is.
Yeah.
So they're the only ones who can be owners.
And no employees
No
other than immediate
employees,
family members.
right?
Yeah.
And they can have multiple businesses covered under that plan. Now that's a little bit of the Wild West, right? Because we don't have a listing of all of it, right? So we're sort of a little bit at a disadvantage that if somebody calls us in on one of those plans, unless they're clearly abusive because they're calling once a week about a different business and we sort of notice it, right? We're probably not going to call them out on it. But that's hopefully I've answered your question.
Okay. Yeah.
That helped?
Yeah.
Jimmy, you had your hand up too, I saw.
Yes, I have a couple of questions. Also, I just in regard to the home business supplement, my understanding is as of February of this year, employees are allowed.
Oh, maybe it is.
Because that's the way that Melissa has been training
Okay.
all year. Okay, so anyway, the two questions I have somewhat related and deal with soft conflicts. One is in terms of getting advice on a for personal guarantee. So let's say that if I am the business owner, I have the small business, one of the small business plans. So obviously the business itself is the member, not me. If I am to sign a personal guarantee in order to get a loan, does it matter if there's a corporate resolution that authorizes me to sign on behalf of the business? So that would still be a conflict, even though there's a corporate resolution authorizing me to.
Yeah, these are these really nettlesome coverage determinations. So this is what I would say. If Jimmy is the only owner of the business and he's signing a loan and has to sign a personal guarantee and wants to ask questions about it, we'll probably answer those questions for you because you're the only business. Where this guarantee issue might arise, where it's going to be a conflict, is if Jimmy and Rick are partners in the business. Rick is a 20% owner, and Rick is the one who calls us to say, Jimmy's borrowing this money, and we're not going to get the loan unless I sign off on it. I sign a personal guarantee. How do I protect myself? Because I'm a 20% owner, but if I sign this guarantee, I'm liable for all of the debt, right? That doesn't seem fair to me. Tell me how I limit my liability for this loan that I'm not necessarily real hot about. Now, I think we have a conflict where Rick is going to really need his own personal plan, and if that even covers it, right? That's another crazy question.
Right.
We're going to have to figure out how to deal with it.
Yes, so that's going to be my second question. With a situation like that, where there's a minority owner who has question about liability of business debt, would that case be referred out, or would that minority owner just have to go to a lawyer outside of the LegalShield network?
If the minority owner, Rick, in our situation, he's got a personal plan we will probably refer him to somebody else to talk to about that. But if he wants somebody to do some work on it beyond the consult, my suggestion is you probably will have to pay that person under the discounted rate to do some work on that to negotiate that deal. Belinda, would you agree that that's probably the most likely way that that would work out?
Yes.
Yeah, yeah.
Yeah, that's probably how that would work out. Okay. So some other coverage issues on that small business plan, designated consultations. This, I think, is really important for everybody to understand that the plan identifies certain areas of law, certain topics that have very, very limited benefits under the plan. And these are really broad. Tax, I mean, think about that. A business owner is calling in with a tax question. That's not unusual at all. Copyright, trademark, patent, securities, which really means their ownership interest in the business, their membership interest, their stock in their own business. Those are securities. We're not talking about publicly traded securities. We're really talking about, their own. These are unregistered securities, right? Their own ownership interest in the business. Intellectual property, which is a very, very broad category. Common example would be trade secrets, for a business, customer lists, business plans, menus for restaurants, recipes, things of that nature. And then out-of-state matters. This is a very, very broad category of topics that business owners might want to call us about, where the benefits under the plan are limited to 3 consults in total per year, right? Not 3 per each one of these, 3. So 1 tax, 1 copyright, 1 out-of-state matter, you're done, right? The good news is, I don't know anybody that keeps track of this stuff, right? So probably the whole 3 thing is not going to be strictly construed. But again, if you've got one business member who's calling in lots and lots of times on tax-related issues, then provider firms may say, hey, I think we've had our 3. We need to, call it on them. So it's really limited to consultation. Also, a very important thing to understand, there's no document review benefit associated with these designated consultations. There's no letter writing associated with it. There's really no 25% discount service benefit either for these matters. Now, from a practical standpoint, I don't think anybody would refuse to extend a discounted referral to somebody who wanted to retain an attorney to do this work. But that's technically what the plan speaks to concerning these issues. So I think I see Harvey with his hand up. Did you have a question about this, Harvey?
No, I had something about the home business supplement that Jimmy had talked about.
Oh.
And I'm sorry, I should have interrupted you before you got into this designated consultations earlier. So yes.
Can I ask you just to hold on to that for a sec? Does anybody have any questions about designated consultations? Teresa? Is that you?
Yeah. So if a business owner calls in with a tax question, does it automatically fall into the designated consultation, or is it part of the advice on unlimited business matters? Because is tax not a business matter?
Well, it is a business matter, but it's a limited benefit. It falls under the designated consultation. So this is just one of those sort of like, I think, I don't want to say sneaky because that's going to come off the wrong way, right? But underappreciated limitations of these plans, right? Where a member who calls in repeatedly about these things may have a provider firm say, we've sort of maxed out for you on this year. I don't think anybody keeps a tight track of the number of consults that they've done for these types of benefits. It's really probably going to come up when somebody calls in repeatedly.
Yeah, and the other thing to keep in mind is patent lawyers have to pass a separate bar from the rest of us. So it's a very specialized field. Tax attorneys generally also have accounting degrees, so they have additional education on top of their standard law degree. So these are areas of law that are very difficult. Very few attorneys, handle these types of areas, very, complicated fields, dealing with a lot of statutes and requirements and things like that. So I think that's the purpose behind, I'm just trying to get into the mind as to why these are considered designated areas, because you are getting a bit of a higher level type of service when you call in on these types of issues.
Yeah, you can get into the weeds pretty fast.
Is there a
Okay,
time limit on the consults or no?
30 minutes each.
30.
Again, I don't think anybody's punching the clock kind of thing. I don't know anybody that does that.
I would say my attorneys don't.
No,
With the amount of time they spend on the phone with members, they never cut people off at 30 minutes.
right. I've been working with, I've known most of the provider lawyers that you all deal with for many, many, many years. And that's really not the culture that's out there, right? But it's there kind of as a governor for somebody that maybe tries to overuse it. Hey, I think we've done our bit. So. All right, associates involved in intakes. I know that Noemi's going to have something to say about this. So sometimes an associate seeks to become involved in a member's request for service. How does that sometimes happen? They might want to assist a member in initiating a request for service because the member has some type of an inability to do that on their own, or a disability of some kind, or whatever, that they can't handle it on their own. The associate might seek to participate in the consultation with the attorney. How does that happen? Again, sometimes somebody has a cognitive deficit and they want to be involved. Sometimes there's a language barrier and the associate wants to be involved to translate whatever the lawyer is saying. Noemi can jump in anywhere she wants on how this happens. Sometimes associates get involved in relaying documents or other information between the member and the provider law firm. Maybe most frequently is that an associate contacts the provider the law firm to address some type of a customer service issue on behalf of the member, right? The associate calls in and says, my member says that they called the law firm and they haven't heard from anybody for 2 weeks. What's going on? Let's get this person some services. Any other ways that this kind of happens?
No, these are all good examples. If you want to assist the member on the initial intake request by introducing them, that's fine. But our customer service reps they are trained to ask the associates to drop off the call. And Mike and Melinda can speak to this. That's just an ethical issue that we have in Pennsylvania. I can't speak to other states, but we can't have you hanging out on the line with the member as they give their scenario or their situation. I have plenty of associates that will send us documentation on behalf of the members directly to me, and we'll get them serviced immediately over to our document team, and we'll get them uploaded. So we welcome that. And then I speak with associates almost daily, not necessarily in bad customer service experience, but we do get a lot of associates calling us and saying, thank you for everything that you did for this member. You went above and beyond. But again, if there is an issue or, sometimes the story might not be complete, or, sometimes, after talking to the associate and the member, there was just a communication breakdown. We try to communicate with texting and calling our members. So but I will keep you in the loop. Typically our CSRs are trained to give me those calls because I'm a little more versed in what can be said and what cannot be said without violating any attorney-client privilege. So if you have any questions about your members' service with us or the intake process, I'm here. You can give me a call and I will answer your call definitely.
Yeah, the real difficulty for us is the attorney-client privilege, right? We're ethically bound to make sure that whatever the member shares with us is confidential. And it's only confidential when there are only two people involved in the communication, the member and us. Once a third person is involved in the conversation, it's no longer confidential for any purpose. So the three people, the associate and the member, may say, well, it's just the three of us that are privy to this conversation, but that's not really the case. It's now not confidential as that's defined by the ethical rules. And so God forbid we get a subpoena saying we would like to have records of these conversations that you've had, and we would have to disclose it because it's not a confidential communication anymore, because it's not a bilateral conversation between us and our client, right, our member. It's
And
very
I can
difficult.
tell you, yeah, that
it's very-
unfortunately, my attorneys will sometimes buzz me and basically say, you know, I was just talking to Mr. Smith and it was very clear he was being coached in the background by his associate, family member, whatever, or the associate is trying to run the conversation. And I've trained my attorneys to terminate the consult at that time and to alert myself and Noemi, because we have a lot of ethical obligations as attorneys, and we can't be communicating advice through third parties, you know, and having the associate intervene at the consult. We just can't do that.
So, you know, language barriers where the associate who thinks that they're doing a kind thing, right? I'll translate. But we have no idea what the associate is saying to the member when it's in a foreign language. Plus, they're involved in the conversation. So it is no longer confidential. Plus, we don't know what they're telling this person. So they may not be relaying the information accurately to the client. And this does involve family members too, where they're calling on behalf of a mom or a dad that is infirm in some way. Again, they think that they're doing the right thing. And, you know, they are, as a child, they're doing the right thing, right? But from our perspective, it presents a difficulty. And it may seem offensive when we say, even in the nicest way possible, I need to speak to your dad another time by just the two of us, sort of a thing. We don't want people to take it that we think that they're doing something bad or nefarious. It's just, that's what our rules of professional conduct require, you know, of us. At least if we have an initial conversation where, you know, we can talk to mom or dad, determine their capacity to the extent that we're able to do that on the phone. And if we're comfortable with it, and they want their child involved, and we can have a good conversation about what that means in the way of confidentiality, then maybe we can bring a third party. Typically, that's really not something that we want to do. It makes the whole process more difficult. So that's a real challenge for us. And again, a lot of people have the best of intentions, but we can't do that. Rick, do you have a question about that?
Yeah. So what do you prefer? You know, that last bullet point about contacting the provider firm to address the issues. You know, we have a formal mechanism to do that. You know, we could log in and, you know, talk about a conflict, or I forget what they call it.
Yeah.
Or we kind of say that the law firm, I got that message from the member and the law firm didn't do XYZ. And, you know, do you prefer that we log that complaint, or do you prefer that we call you? I mean, I try to call the law firm myself because there's always two sides to everything. And, but I didn't, and I don't want to like report them and have anything negative reflect on the law firm. So I don't know what you prefer.
I think, well, I'll tell you what's going to happen if you call the home office. They're just going to tell us to call the member. So all you're doing, it's like, you know, it's like, you know, leaving your front door and entering the house via the back door by going around the block. You can get there a lot faster by just, you know, going around the corner of the house. So our preference, and I think pretty much every administrator would tell you that the best thing to do would be just to contact the law firm directly and say, hey, this member said they haven't heard from you. Could you please address it? That's all you really need to say. And, you know, sometimes we have missed the call. We haven't done a
Mhm.
lot. But, you know, 99 times out of 100, you know, it's really good for associates to understand the various means by which your provider law firm communicates with members. And it's almost always via the phone, voicemail, email, texts, push notifications in the app. They almost always, a member, when we've tried to get a hold of them, has received 2 or more forms of communication saying, we'd love to talk to you, right? But perhaps it went into their junk email, or they missed, or their phone, they didn't listen to the voice message, or they didn't check their texts, you know, whatever, that kind of stuff, right? So you're better off. I think the best thing to do is just let the provider firm know, I got this concern from my customer, could you please address it? And the firm was going to say, absolutely, we'll take care of it, right? And
Yeah,
maybe they'll even let you know, hey, I spoke to Mrs. So-and-so, just want to let you know.
Yeah.
Right, as a follow-up.
Yeah, I encourage all associates, if you have an issue, it's best to reach out to me rather than going to your resolution channel that you guys are directed to use, because also sometimes that also delays service still to the member, because, you know, they may get it and may take 24 to 48 hours to get to us. Well, now service is even delayed more for the member. So the minute you get that call, reach out to me, I'll check into it. And like Mike said, a lot of times, members don't have our phone number saved, so they don't recognize the number when it appears. As soon as we find that out, we encourage them to save it under FIFIC Law Group, your legal shield provider firm, in their cell phone, so that they know we're calling or texting them. So we try to, resolve the issue so it doesn't happen again.
Right.
And a lot of times, if it's phone tag, we can try and get a phone appointment set up. If maybe the member just missed the call and the attorney has moved on, so then Noemi will say, hey, Belinda, you just tried this person this morning. Their associate called in. Do you think we can give them a call this afternoon? I'll say, sure. So it's, a lot of times it's just, there's been some sort of disconnect. No matter how many times we've tried to reach out, maybe the member doesn't get text messages. Maybe they just have landlines. We have a lot of older members. We have an Amish community that we service, so there's various means that we use that maybe they don't receive. So, we're always willing to try and reach out to members and meet them where they're at, even if that means setting up phone appointments, things of that nature. So,
Yep.
And it does. Noemi's right. It moves so much faster if you just call us, because if you call LegalShield, then they open up a file, then they send us an email, then our our concierge person has to reach out to, it delays everything. There's so many steps we have to follow. Whereas if you just call us, it gets handled much faster.
Right.
And
Nobody's
Rick,
going to be
I
mad.
usually, no. And Rick, I usually will follow up with you and say, hey, Rick, what you called me on, that member's been serviced, everything's okay now. Just to give you a peace of mind, so that it was taken care of.
Yep.
Yeah, that's been my experience here in Missouri. I'm usually reaching out because the member calls me and says, I've gotten some crazy things that they've told me that the law firm has done or hasn't done. And it's not always just that they haven't called. So it's usually some contact they've made that they're not happy with. And usually if I email Greg or whoever that was involved in it, they'll respond to me. And, I don't want to know any of the details about the issues. It's just, they need to know what the member's perception was. And maybe if they can take another step or do something else, then great. So,
Yep. Greg May, Laura Berlin do a great job.
Yeah, absolutely.
All right, a couple of LegalShield app dates. Sorry for the pun. Let's talk about it. So the LegalShield app is constantly changing. So please download app updates and encourage your members to download those updates regularly. The functionality has changed significantly since the early days of when it was rolled out. I'm not talking about the way early. I'm talking about like last year. They are constantly pushing updates out. The ASAP callback option has been eliminated. So if your members still see ASAP as a callback option, that just doesn't exist anymore. And it really creates an inaccurate service expectation, because everybody defines ASAP ASAP differently. ASAP, for some people, means call me right away, right? Or it might literally mean as soon as you have an opportunity to call me, but not necessarily in the next 15 minutes. So that's really was a, they had better thoughts about that option and got rid of it. So for everybody's benefit, it's best that be updated. It'll go away. Newer versions of the app, and maybe you've experienced this, will have some type of push notification features. So if we are communicating or if some type of a status has changed about a member's matter or that they've opened using the app or the web portal or whatever it is, they're going to get notifications that some type of a status has changed about it. Maybe we've tried to call them. So there are communications that are built within the functionality of that app. And LegalShield is really trying to move members more towards using the app. I know that that's not going to work for a lot of members because they're older, they don't use the app, don't want another app, they've got a million apps already, whatever it is, but that's just the reality of the direction the company is going. They would really like for folks to use their app more frequently. Provider firms are using the calling soon feature that may result in a push notification, or it may actually send a text to your members. So the lawyer may be hitting a button on their end that pushes a text or a push notification out to your customer to say, I'm going to be calling you here very soon. Really what that's intended to do is give your customer a heads up in the event that they're in a place that they can't have a private conversation or a meeting or whatever, to sort of boogie out of there and find a spot where they can receive a call. There are no hard and fast rules about when that button gets pushed versus when the attorney calls, but I would say it's going to be less than 5 minutes in most instances, where the lawyer is maybe finishing up something that they're doing. So they hit this calling soon feature, and then a few minutes later, they're going to try to make a phone call just so that this person has an idea that something's about to happen in the very near future. You may want to be ready for it. The app will also very soon, I think this functionality is rolling out this week, provide for private messages from the lawyer that have been working with them to the member. That will be within the intake file for whatever the legal matter is that they open. That functionality will be available so the lawyer may want to send a note to the member about whatever it is that they're talking about within the app. That's something that only the member can see. Right? It's not sent by text. It's really sent only via the app. And the attorneys can also upload documents that members can view via the app as well. So maybe they've done a letter for the member and they upload that letter to the app, in the intake in the app so that the member has that available to them. So, I don't know how much lawyers will be using these features because we don't always know on our end whether the member has the app or not. So we may or may not be uploading documents or messages if we don't know whether somebody's actually going to be viewing them or not. So, but those features are available. So your customers may want to start looking for those things. And maybe the company's told you about that, maybe not, but that's going to be something that's happening soon. If you don't have the most recent version of the app, it's not going to be happening, right? So this is another reason why everybody should be trying to update the app relatively frequently so that you will be able to take advantage of these new features.
And that's especially true because sometimes you need to patch it because sometimes things get released, just like anything that's newly released. There's always bugs and glitches and things don't come through. I saw Harvey said he got a message on a Sunday saying an attorney was going to call him and then he never got the call. So, I don't know necessarily when the attorney sent that, or what it was, but it's, sometimes there's quirks in the system and they don't work perfectly. So, on behalf of my attorneys, just exercise a little bit of patience. We're trying to send the notifications and use the app and completely, and every now and then it's just, the attorneys are like, but I did send the text, and the members say, I didn't get the text, and it's Technology's funny sometimes.
That's right. They're on the phone on a Friday,
Belinda?
and then the text comes through on Saturday. I'm calling soon. What?
They
Oh
were
my God, the
having
lawyer's
some-
calling me on Saturday? This is great. Did not happen.
LegalShield was having some technical issues over from last week into the weekend.
Yeah,
Yeah.
so that kind of happens.
So Harvey probably got a message that the attorney sent on Friday, on Sunday, so that happens. Happens with my emails sometimes. I get emails from someone the week before, and it doesn't show up in my box until Monday, so.
Yeah. Yeah, we communicate a lot via text because we know that most people, they don't, whether they have the app or not, they almost always get texts. That's a great way for us to communicate with members. So we are texting outside the bounds of the app, and our members seem to really like it. I know that other provider firms use texting as well. Not everybody, but a lot of them do. So they're probably going to be getting text messages in addition to messages via the app. Okay, if you're in Pennsylvania or if you sell in Pennsylvania, we have an online will tool that we love to use, and it's available on the LegalShield page of the Fifth Law Group website. And we like to say that it's an alternative to the LegalShield will questionnaire, right? And the nice thing about it is it's available 24/7. It works on any device with an internet connection. So phone, tablet, computer, whatever it is that you've got, it's going to work for you. It has interactive questions. So it's not a form. It's like a bot, as they say, right? So a little question comes up, you answer it, and depending on how you answer it, another question comes up. And so it's guided by the information that you provided to ask questions that are relevant to your family situation. Unlike the LegalShield questionnaire, which is not necessarily readily available anymore, it's always there and it's always available. It's always on our website. If you go on to the LegalShield page on our website, you'll go onto the page and then all of a sudden it'll pop up, and that's the little tool. It'll say, "Hi, how you doing? Time to get people started. Let's go ahead and move forward." The very nice thing that I like about it is, remember, there's no need to print the questionnaire, to fill it out, to scan it back, to fax it to us, to email it to us. So it really kind of takes the friction out of the entire process, right? It's always there. You pull up the page, it pops up, you answer the questions, takes about 10, 12 minutes, and then we have all the information, most of the information that we need to get things going. And we are finding that for our members that use our online will tool, we are pushing drafts of documents out to them in about 24 to 48 hours. So we're getting stuff to them right away. So think about how powerful that is for a new customer that you've signed up. If you can direct them to this online tool on our website and they fill that out, they're going to have tangible evidence of their membership benefits in their hands, right, in 24 to 48 hours. So it really kind of delivers a lot of punch, we think, in the way of a benefit. And I'll show you a little bit of what it looks like. So if you're on our website, this will pop up, right? This is a little bit of a fuzzy picture, but it says, "Congratulations on starting your estate planning. We make it easy to protect your family. You're about to answer a series of questions intended to allow us to create your estate planning documents." So it'll go ahead and just ask you some questions about your family situation. And it will ultimately allow us to produce a will, financial power of attorney, and healthcare power of attorney very quickly for folks that we can push out. And hey, quick is the name of the game, right? Everybody wants to get this stuff done whenever they want to get it done.